Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride.
I forgot to add my stage, ladies and gentlemen. I'm pouring myself a Coca-Cola with a treat. I hope everybody's doing well today. Very hoodie forward today. But we are in courts, 3 different places have put in a grocery for later that I'm going to go pick up. I'm excited about that. It's here, and so I'm hungry. Internet for me, yes. It does seem that way. Let's get rid of me because I'm the one that has the problems. Heard that before.
Yes, that's right.
I got a cheater bacon too.
Rebecca Hargrove versus Devin Cook.
Can you go there? Where's that black box, please, sir? Sir, are you Devin Cook?
Yes, sir.
Right, for the record, Devin Cook is appearing this morning via Zoom from the Iosco County, Michigan jail. He's been arrested on a bench warrant issued the request of the Monroe County front of the court. Also present this morning for the Zoom hearing is Monroe County front of the court attorney Rebecca Hicks. Good morning, Ms. Hicks.
Good morning, Your Honor.
And Mr. Cook, are you being, first of all, can you state your name and current mailing address for the record?
My name is Devin. Cook.
Change of address. So the notice to appear and you don't appear, bench warrant issues, it's your fault.
I understand that.
Are you being held in jail on?
I was
Mr.
actually
Cook,
homeless from that time frame.
Are you being held in jail on any criminal charges?
Say that again?
Are you being held in jail on any criminal charges this morning?
No.
Okay. Are you currently employed?
No.
How do you support yourself?
I DoorDash.
Well, I hate to tell you, buddy, that's an employee. You're employed. That's gig work. It's a hustle. But that's a job, as little as we would like to think about it. My camera is not working very well today, but, well, I don't know what's actually going on with the internet. It's been shite today. Hi, Courtney. How's the weather today in Florida? When my brain has to do like grocery order day and like plan food that I'm actually going to eat for like the next 3 weeks, 2 weeks, because I really have to, like, I just can't eat out anymore. I'm always thinking of crazy, funny recipes, but Anyways, how's Florida? Slightly cooler and less humid than yesterday. All right, that's doing good. That's doing good. The weather is fine here. It always is fine. Let's continue.
Okay, so you are employed. How much do you take home each weekend from DoorDash?
Each week, if I work every day, I could bring home roughly $100
Every week.
day or per week?
per week.
Okay, so how do you pay rent and food on $100 a week?
That's where I'm at right now. I'm actually living with a veteran, because of the fact of I can't get a job right now. I haven't been able to find a job. I don't have a vehicle, so I'm trying to find a job that I can walk to.
How do you DoorDash?
And with me being homeless and being in and out of mental hospitals, I didn't even realize that I had a court date.
Well, are you aware that you have an obligation to pay child support?
Say that again?
Are you aware that you have an obligation to pay child support?
Yes, I've been trying to get a job to pay
So,
child
Mr.
support.
Mr. Cook, think about it for a minute. If you're ordered to pay child support, you're not paying child support, there's a really, really, really good chance there's a bench run out for your arrest. Would you agree?
Agreed.
Okay, Mr. Cook, I don't know about Oscoda County, but here in Monroe County, their employers screaming for employees. I can get you a job today. Maybe we move back to Monroe County if you have family back here. Mr. Cook, you need to get a job. And you need to be proactive and file a motion to reduce your support. If you don't have the income, you need to reduce your support. Ms. Hicks, can you provide the court a little background on Mr. Cook in this file, please?
Certainly, Your Honor. This is a fairly new child support obligation. It started in December of 2023. The current monthly support obligation is $110 per month, and the balance is $690.22. There was a referee show cause hearing on March 27th, where Mr. Cook failed to appear, and a recommendation was made for a bench warrant to enter, and that's the bench warrant that he was arrested on today.
All right, so Mr. Cook, if you can't afford the $101 a month, you need to file a motion to reduce your support. You got to be proactive. You can't sit on your hands because this is going to start piling along until you file a motion.
I agreed, Your Honor.
Okay, so did you have any money in your property when you were arrested?
I didn't have any money.
Okay, well, this person you live with, can they post a cash bond on your behalf?
Say that last part again.
The person that is supporting you, can they post a cash bond on your behalf?
Who I'm staying with is actually somebody that was in a mental institution with me. And that's the only reason that I took the steps that I took to come to Oscoda.
Okay, do you have any questions? Again, the court, you're authorized release today. I'm gonna.
Get anybody's attention by knocking.
Okay. So what are you gonna do when we're done? You're just gonna sit there until someone comes?
I'm not sure what I can do, Your Honor.
You don't see anyone outside?
I'm on my end.
What happened there?
Ms. Hicks, perhaps you can call up there to get a.
It's jumping around, but it's not. What's going on? Hector, welcome. Lurk away. I'm also lurking today. I'm lurking as well while hosting. It's a unique position to be in. The lurkin' host. The lurk host. Lurk host?
This court appointed, she don't wanna. Dip us in the file, so.
That ended so abruptly. Oh, what is going on? It was like a cut slice, like a cut. What do they call that? God damn it, Paisley. Lurk. Lurk, god damn it. Donna says, no, don't lurk. So thank you. Do. Happy Monday, Miss Donna. Thinking about you too. How is Orlando weather? Jealous. I want to be in Florida right now. Don't do that, Paisley. Your hair, your eyes will get stuck in your head. No. Thank you again so much, Miss Donna. That's awesome. I gotta dip off the screen because I think I'm making it choppy or something. But Judge Bromlick is in no mood. Oh, it's a gorgeous day. I love it. Judge Bromlick here is in no mood to be dealing with people and their sass.
Use it in the future. Sir, could you please state your name and current address for the record?
Derek Sanford and 19 Michigan 48219.
Thank you. For the record, Mr. Sanford is appearing this morning from the via Zoom from the Monroe County Jail. Also present is Monroe County Front of the Court Attorney Rebecca Hicks. Ms. Hicks, can you provide the course some information regarding Mr. Sanford?
Payments made by Mr. Sanford on this case. There was
Jail. Since possibly of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to
What is
represent your public
happening?
interest.
You guys, what is happening? It's jumping around. I don't understand. Mama Llama, you didn't get an alert? Sometimes I don't know why, to be honest with you. Okay, we got to do something about this. We got to do a different video. Jesus Christ, phone. Stop. Let's hope this video is better. Judge number 2. Ooh, see, grilled chicken kebabs sound delicious. This is Alicia Fink. Magistrate Fink. Oh, there's a lady back there. I'm still considering dinner options too. Well, my dinner is going to be very late tonight when I pick up groceries. I just managed to catch this today. I don't know what it is. I just saw it and I got it. Like a kid at a piñata party. I know. Well, cheater bacon is on order. Oh, charcoal grill. Nice. Lucky, lucky, lucky. That's a humble brag. Chicken kebabs.
Now you can hear me.
Yeah, but who are you?
I hear you.
Mama Llama. That sounds delicious. That sounds super yummy. Cheater bacon by... Now, I hope we're talking about the same bacon. It's just microwavable bacon that's already cooked. Hello, Miss Erica. Microwave bacon you buy by the packet. And it's cheapest you can get here would be Walmart like great value, and that is $5. And you get 2 packs. I like to grill. I actually grill quite a bit. I know that sounds like a really yummy dinner, right? I'm like, all that meat. Judge Fink, where are you? I think it just means you're cheating and cooking it in the microwave. I like microwave bacon because you can do it in the air fryer really fast too. It's basically the kind that you'll get at most fast food restaurants. And so I've taken to using it. Oh, I'll just do a little scroll. Wouldn't it? Oh, I was going to say, wouldn't it be funny if she's fucking psyching us all out here and she's not going to come out? But here she is. Ladies and gentlemen. Also, it can get really crispy, actually. You can cook it too long really easily. I really like pre-cooked bacon as well. It's real bacon. I would call it maybe easy bacon or microwave bacon. But I like to buy, if it's on sale, there's a grocery store near our place called Red Barn Market, and they make double smoked bacon, and I buy the bacon end pieces, and it's very good. But I usually only do that when it's 20% off, and I buy a bunch of them, and then I like cook them up, and then I have them in a container ready to go. And it's double smoked, so it's already like cooked technically the same way. So while you still cook it again and it's thick, it is like really good quality pre-cooked bacon in a way. And they have a maple flavored one. It's really good. But if I buy it like by the pound and it's not on sale, and I just buy the strips instead of buying like the end pieces when they're on sale, it's like a lot. Like a lot. Probably $10 or $12 for a pound of bacon. But again, very, very, very good quality. And even the end bits when they're on sale is still going to be like $10 or whatever, but you get a lot of it. And oftentimes it is still just strips of bacon, and it's what you would think of as American bacon, strip bacon. Yeah. And it's really good.
All right, we're ready. We need one of the microphones on in the jail, please.
I like that. I like that. I ordered strawberries because they were on sale today, and I'm going to be making
Okay.
those strawberries.
All right, we're gonna do the gentleman that's in the hospital, do his arraignment first. In case you didn't already notice, we are live on YouTube for a little while. So just keeping that in mind. Deputy Howard, can you join us? Hello, sir. What's your name?
My name is Lamar Parker.
All right. I don't know if you heard me say that we're on YouTube today, Mr. Parker.
Not get a.
Just letting you know, I'm sorry, I'm having some trouble with my computer. I'm just letting you know so that you are not surprised by that. Okay, I'm not
Okay.
going to get any contact information from you since we are on YouTube. But Mr. Bowling, when you get a chance to forward that information, if you could please do that.
Will do.
This is State of Michigan versus Lamar Parker, 24 FB 1246. I will appoint the Public Defender's Office. Go ahead when you're ready, Mr. Bowling.
Thank you, Your Honor.
Is it good, Hector? I just saw it and grabbed it and thought, oh, we can do 3 different judges because they're the perfect length clips. Oh, dirty rice sounds good. All bacon can be. You guys, you've never heard of microwave bacon? It is very, very thin, and it like it is delightful. Let's watch this clip then. Let's do it. Let's do it.
Brian Bowling, Assistant Public Defender, on behalf of Mr. Parker. Your Honor, the complaint was not ready when I spoke to Mr. Parker earlier today, so I would request a formal reading of the charges.
The complaint in this matter states that on or about May 17th, 2024 at 1021 Nash in Ypsilanti Township, Washtenaw County, Michigan, defendant is accused in count 1 of committing the crime of homicide, charged as open murder. That has a maximum penalty of life in prison. The alleged victim, the decedent, is Nicholas Jernigan. Count 2 is a charge of carrying a concealed weapon that has a maximum penalty of 5 years and or $2,500. Count 3 is a charge of being in possession of a firearm when prohibited by law. That has a maximum penalty of 5 years and or $5,000. Count 4 is being in possession of ammunition when prohibited by law. That is also 5 years and or $5,000. And count 5 is being in possession of a firearm at the time a felony was being committed, the felony being the open murder charge. That charge is 2 years that needs to be served if convicted consecutively with any preceding term of imprisonment imposed for the underlying felony.
We'd waive stay on mute to those charges, Your Honor, and just ask for an opportunity to address bond.
All right, thank you. Go ahead, Mr. Emmons.
Your Honor, I think that the bond form that the court should be in receipt of speaks to a lot of the circumstances surrounding the altercation, but ultimately this is a homicide case, and therefore pursuant to the court rule and the statute, we're asking for the court to deny pretrial release.
Okay. Did you, I know Detective Morrison was on a moment ago. Do you need any of the sheriff's deputies or detectives to say anything?
I have not reached out to any of them.
Okay.
So if they had anything that they wanted to add, in addition to, I'd invite them to make such a request.
Detective Morrison, did you want to make a statement today?
No, Your Honor, you took the swear too, so you're aware of all the information.
I did, and I am. Thank you. Okay, Mr. Bowling, go ahead when you're ready.
Thank you, Your Honor. Just a little information for you about Mr. Parker. He is 45 years old. Your Honor, I don't see anything on a criminal history getting to the nature of count 1 in this matter. Mr. Parker indicates to me that this was a result of a self-defense situation. He is employed, self-employed, running a lawn service company. He and his family did just recently move to Toledo, Ohio, Your Honor. So that's why the court-appointed attorney for him did not have a current address because he could not remember that off the top of his head when I spoke to him earlier today. But he did provide me a phone number that should be on the court-appointed attorney form. Your Honor, I'd always ask the court to consider granting a personal bond to Mr. Parker. Obviously, he's been not convicted of anything as he sits here right now. But obviously, I'll leave that to your discretion. Thank you, Judge.
Mr. Parker, the court rule that controls pretrial release considerations is Michigan Court Rule 6.106. Subsection A states that subsection B states the court may deny pretrial release to a defendant that is charged with murder. It's the general policy of the courts in Washtenaw County, my court as well as the other courts, to deny bond when someone is charged with murder based on that court rule. So I am denying your bond today. That means that you do not have any amount of money that you can post to leave the custody of the sheriff's department. When you're able to leave the hospital, you will be taken to the Washtenaw County Jail. While you're on bond, you're not to use illegal drugs, do not purchase or possess any firearms or other weapons or ammunition, no contact with the family of Nicholas Jernigan, including his wife, Kiana, or her family members. I know you're married to Kiana's sister, or I believe that you are. You may have contact with her, but not the other family members. I'm not telling you can't speak to your wife.
Okay. Your Honor, Your Honor, it's a self-defense case.
That's not before me today.
Okay.
And my job is not to decide what actually happened. So you're represented by the public defender's office at your next hearing. Your bond can be addressed at that time and modified if that's appropriate. Your next hearing will be on May 30th at 9 a.m. with Judge Simpson. Okay, anything else on this matter? Okay, all right, thank you.
Nothing further from the defense. Judge, I was just gonna say, while you had the file in front of you, I missed the case number. Could I get that, please?
Yes, 24F like Frank, B like boy, 1246.
Thank you, Judge.
And Mr. Bowling, I don't believe we have the court-appointed lawyer form from you. So when you can, if you can send that along, we'll put it in the file.
All right,
Okay,
I'll resend it
Deputy.
right now. Thank you.
Okay, thank you. Thank you, Mr. Parker. Deputy Howard, we're all set.
I'm sorry, Your Honor, if I could just get the PCC date again.
That is the 30th, May 30.
Thank you.
I'm picking
right.
up seats later too, Mama Llama. I'm gonna buy my favorite Haribo Coca-Cola bottles. I think that's gonna be my treat. Yeah. Oh, and Rice Krispies I gotta add to the list. God damn it. Honestly, if I just bought everything I wanted, it would be hundreds and hundreds and hundreds of dollars. But I wanted to make Rice Krispie squares. Well, just in a bowl. Hi, Lucy. But and I have the I already have the marshmallows, so I just need the Rice Krispies. So many things on the list.
I think the person we want to see next is Mr. Fleming. Can we get Mr. Fleming's microphone on? They can hear me.
Chili sounds
Mr.
good.
Fleming, can you walk to the door and let the corrections officers know we're ready to proceed?
Me too. They're great. Like you can make your own version, like a small version in the microwave. Sorry, Courtney, without the microwave, but you can make it on the stovetop really easily as well. You just melt down.
I'll get that microphone turned on for you. You can sit back down.
God damn it. We're trying to talk about Rice Krispies.
Thank you. Go ahead and state your name, sir.
Ronald Fleming.
All right, Mr. Fleming, you provided a phone number and an email to the public defender. Is it all right with you if I use those methods? If I put those in your file for the court to contact you?
Yes, that's fine.
Okay, thank you. This is State of Michigan versus Ronald Fleming, 24FB 1245. I will sign the petition requesting a court-appointed lawyer. Go ahead when you're ready, Ms. Vergils.
Assistant Public Defender Chelsea Vergils, with and on behalf of Ronald Fleming, you would waive a formal reading of the complaint, stand mute, and ask to address bond.
Go ahead, Mr. Emmons.
Your Honor, thank you again, Your Honor. And again, Jonathan Emmons on behalf of people. Likewise, in this case, this is a case of homicide, open murder. We're going to ask the court, accordingly, pursuant to the court rule, to deny pretrial release in this position. The underlying circumstances are well laid out in the bond form as well. It's obviously there's going to be a contested defense, and that's one that I think ultimately is best left for a jury to decide. However, I would suggest that the information that we have doesn't really bear out that defense is that there's a lot of weight behind that defense. That being the case, Your Honor, I also have the court take into considerations the actions of the defendant after the crime was committed, in trying to cover up what he had done. I think speaks to a lot of concern for what he had done, the intent behind what he had done, and gives me a great amount of concern of what might happen, if he were to be released. So for those reasons, I would ask that he remain in the care and custody of the Washtenaw County Sheriff's Department.
Thank you. Go ahead, Ms. Vergils.
Thank you, Your Honor. I understand that there is a possibility of bond denial in this case, but I wanted to put a few things on the record. I would argue that my client is not a danger to the community, as from what I can tell, he does not have a criminal history in Michigan. He denies having any criminal history, and he is not a drug user, and he is also not on probation or parole at this time. He has family, including his mother and siblings, close by in Toledo, Ohio. If released, he would stay with his mother in Toledo. He does not know her address at this time, and I understand we have to confirm that before he is able to be released. As always, I would ask for a personal bond or consider not denying bond in this case. Thank you.
Thank you. Mr. Fleming, the court rule that controls pretrial release and bond considerations is Michigan Court Rule 6.106 sub B states that the court may deny pretrial release to a defendant that is charged with murder. It is the ordinary and usual policy of the courts in Washtenaw County to deny bond when someone is charged with murder. So your bond is denied at this time. Your court date will be on May 30th at 9 a.m. That will be in person with Judge Simpson. While you are on bond, you're not to use illegal drugs, don't commit any crimes, no firearms, weapons, or ammunition. Okay, you're all set. When you're ready, you can walk to the door, Mr. Fleming. Thank you.
Thank you, Your Honor.
Thank you.
Denied.
Get us off of YouTube, please.
But all of them denied. No murderer shall pass. Alleged murderer shall pass today in front of Judge Magistrate Fink. She doesn't like YouTube very much. Okay, let's do one more. Yeah, keep an eye on that. Keep an eye on that. Okay, give me 1 second. We did. You got me hungry for justice. No, but legit hungry for like chicken tonight. I'm craving chicken, and very rarely do I crave like meat, but I want chicken. Felicia is right over here. Felicia, did you want to be on?
37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2021 8DM Shannon Beckman versus Frederick Beckman. Today is Monday, May 20th, 2024 at 9:02 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff, Mr. Holak on behalf of the defendant. This matter is before the court on the plaintiff's motion for counseling and other relief. Ms. Podolsky.
Thank you, Your Honor. First, I would state if the defendant filed an answer to our motion, we did not receive it. But proceeding forward, I think our motion is pretty clear. There have been a lot of different things happening within the home in the last month. We've got 2 minor children. The party's daughter is going to be 18 in July. She graduates here in just a few days. Their son is going to be 16 years old in July. We've had issues in the home of the plaintiff regarding disrespect, not following the rules, and essentially trying to pit the parents against each other. The defendant father is playing into all of this. He's treating this as a game of he needs to beat plaintiff rather than trying to encourage a relationship and work together and co-parent in the best interests of the minor children. He has been denying parenting time. For the last 2 weeks of mom's parenting time, he has not encouraged the minor son to attend parenting time. He has done nothing of the sort. He's just kept him home. Instead, calls plaintiff on the phone with the minor child present, calling her names, swearing at her, buying him video game systems, not enforcing the rules and whatnot that's happening in plaintiff's home. We're very concerned about this because this is a violation of the inalienable rights. It's the denial of parenting time. And then he had a phone call with the party's daughter, wherein he admits to pressuring her to do what he wants and say what he wants in court. It was a phone call riddled with lies, gaslighting, and anger by defendant father when the party's daughter wouldn't agree to do what he wanted. At this point, we think this case is ripe for co-parenting counseling and counseling between both parties and the party's son, who I stated will be 16 in July. This is a chance to address this issue head on very early and repair these relationships and get these parties on the same page to be able to co-parent together. So we're asking the court to order co-parenting counseling and family counseling with Margaret Hunter. Based on what we've outlined in our motion, the communication.
Didn't we fucking hear Margaret Hunter recently in that last case? Wasn't she that allegedly terrible? Also, I got another case today where the kid's name was Birdie. Super weird. Can anybody else remember what I said I was picking up? Oh, I wanted Rice Krispies, Coke bottles. Such a weird thing.
That's been occurring between the parties, namely the name calling and swearing by defendant towards plaintiff. We're asking the court to order that the parties solely use our family wizard for communication as well. Thank you.
Thank you. Mr. Holak?
Yes, Your Honor. Everything that was said there, my client heartily disagrees with. It is my understanding that the plaintiff, Ms. Shannon Beckman, has recently entered a new relationship. This relationship has become toxic, especially for the children. The children no longer feel welcome there. In fact, they feel threatened and intimidated by mother's new partner. Because of this, the son especially has indicated his desire to live full-time with father. And father has never denied parenting time to mother. In fact, he consulted me about this repeatedly and was not in any way attempting to diminish mother's parenting time. The son simply does not want to go with her. And when mother went to pick him up, he refused to go. And obviously it's not my client's job to restrain him and force him to go with mother. This is just done of the child's own volition. As for the calls, the threats that were alleged to have happened by my client alleges that it's the other way around, that Shannon Beckman has been calling him, threatening him, gaslighting him, and demanding that the children be returned to her, even though they do not want to be there due to the toxic family situation that's currently taking place there. As for this phone call, the daughter has since indicated her desire to live with father full-time because she was manipulated into making this call, trying to instigate my client into saying something that might potentially be harmful to his case. So Ms. Shannon Beckman is using the kids as tools in a game here, trying to improve her position rather than seeking out the best interest of the children.
Mr. Holak, if that's the case, don't you think that counseling would be assistance in ferreting out some of these issues?
Well, Your Honor, we filed a motion for modification of parenting time, which I believe the court either has received or should be receiving shortly. It was filed late last week. So my client wants to move forward and amend parenting time due to the wishes of the children. He believes that that would be in their best interests. Therefore, I don't believe counseling necessarily would be, I think we're past that. Perhaps mediation to see if we could work out something short of litigation that would be in the best interest of the children and the parties. But I talked with my client about counseling, and he believes that based on Ms. Beckman's actions, that it would be pointless.
Well, good thing that he's not the one making the decision, sir. It does appear that there are substantial reasons and issues in this case that need to be addressed, and I think best to have them done through counseling. The court will grant the motion, order counseling with Ms. Hunter. Court would order that the parties would contact Ms. Hunter within 30 days of today's date to set up appointments to meet with her. And the court would order that the parties would have their communication through our family wizard. That way the court has access to that. I will tell the parties in this matter that there is a permanent record kept of all that communication through our family wizard. So be aware that the court will have access to that. So Ms. Podolsky, you can prepare the order and submit under 7-day notice of entry.
Thank you.
Okay, thank you.
Kelly, if you want to stay on.
Yep, I have my client here.
Let me check my waiting room. See, just to confirm that we do not have Roy Clark. Roy Clark is not in the waiting room.
No, we'll proceed anyway. It's 9:08. It was set for 9 o'clock.
I'm sending you both of the orders.
He looks different, sounds the exact same.
Calling case 2024-300 DC, Roy Clark versus Amaya Watson. Today is Monday, May 20th, 2024 at 9:09 a.m.
Court will note that this matter is before the court on the defendant's notice for entry of order of default, order of custody support parenting time. The defendant is represented by Ms. Podolsky in this matter. Ms. Podolsky, we don't have a friend of the court approval of that yet. Did you get that?
Let me see.
At least let's say we didn't have it when I prepped the matter.
We don't have it yet. It was sent on the 14th and we don't have a response yet.
Okay. Well, what happens, the court will take the matter under advisement. I'll enter it at such time as we do have a friend of the court approval. So is there anything else, Ms. Podolsky?
I would just like to make a quick record because Mr. Clark does have a history of filing motions and objections. He is the plaintiff in this matter. He filed the complaint for custody, which was answered. We appeared at the scheduling conference. He failed to appear. Rather than have the case dismissed at that time, we filed a counter complaint for custody. He failed to respond to that and the default was filed. We have filed motions, attended those motion hearings, orders have been granted. He has filed his own motions. Orders have issued after those motions. He's filed objections and further orders have issued. And now he is not here today. So I just wanted to make a record of why we did what we did in the event he does wish to appear later on.
That's fine. And the court will note that it's now 9:11 a.m. It was scheduled for 9 o'clock and the plaintiff has not appeared. So the court will enter the order at such time as we get front of the court approval.
All right. Thank you, Judge.
Okay, thank you. Have a good day.
You as well. Thank you.
All right.
Christy, make note of that because I've taken under advisement. I can enter it without having it
Okay.
set up for entry as soon as we get FOC approval.
All right. Take note of that. Arbor guys,
older.
next case.
Okay.
We do have plaintiff, defendant, attorney Thomas and attorney Frost.
You know what's going to happen if I buy the Coke bottles? I will eat them all.
Oh, no, wait a minute. All right, I'm sorry, Cindy, I'm gonna put you in the waiting room.
Okay, no problem.
You and your creepy president bust too.
Calling case 2022-625 DM Dana Arbogast versus Travis Arbogast. Today is Monday, May 20th, 2024 at 9:12 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff. Are you Mr. Frost?
Yeah, yes, Your Honor. Mahmoud Talib here on behalf of defendant Travis.
Okay, thanks. I
Arbogast.
just had a different name at the bottom and I thought, okay.
Yes, Your Honor. I'm stepping in for undersigned counsel. She's not able to make it today.
Okay. Court will note that this matter is before the court on the plaintiff's motion for modification of support. We did get a answer filed by the defendant. I've reviewed all that. Anything else, Ms. McNiff?
Yes, Your Honor. Actually, my client believes that they only had one attorney, her attorney, at the time of the divorce. And it's accurate that there's not actual deviation language in the support order. However, sometimes attorneys do deviate without actually having the deviation language. And her recollection is that the child support should have been $1,900 at that time, and that they agreed on $1,700 without putting in that particular language. I'm not sure how the attorney calculated that in order to make that happen. However, there has been the change of circumstances in that Mr. Arbogast has a new job. He has a different employer than he did at the time of the divorce. The time of the divorce, she believes that he was making approximately $111,000 a year, and that now with the new job and a promotion at the new job, that his income is significantly increased to $250,000 a year. So what we're looking for is a child support recalculation, which would remove the need for their oral agreement regarding any extracurricular expenses.
Okay, thank you. Ms. Frost?
Your Honor, before we have a motion to modify motion to modify parenting time and custody forthcoming. So before this honorable court makes any decisions on child support, we would ask that that motion be heard.
Well, it's going to take a while for that motion to be heard. We can get the motion heard, but it's if we're going to have an evidentiary hearing, it's going to take some time. Court's going to refer the matter to the front of the court in this case for. When I do that, I'll refer it for a investigation on child support, and once that investigation is completed, then we can I'll have it set for a referee hearing on that on support issue, and at that particular time, maybe we'll get further into the other motion as well. Court would note that if obviously, if support is modified, it would be the intent of the court to vacate the provision for payment of expenses. So that's not going to continue if the support is modified and is consistent to the support guidelines. Anything else, Ms. McNiff?
No, Your Honor. Do you want me to prepare an order, or are you just going to refer it to front of the court?
We'll refer it if you would prepare an order, however, saying that upon a modification of support, that provision for the payment of expenses would be vacated.
Will do, Your Honor.
Okay. Anything else, Mr. Frost?
No, Your Honor.
Okay. Thank you. Oh, you're free to go. Have a good day.
Thank you.
Thank you.
Can you just put me back in the waiting room so I still have at 9:30?
Yeah. All right, I'm going to bring Attorney Thomas and Jennifer Reed in. This is Martin v. Martin. There we go.
Creepy.
Good morning.
Good morning.
Calling case 2024-845 DM Michelle Martin versus Derek Martin. Today is Monday, May 20th, 2024 at 9:06.
Quoted plaintiff's own words where she has in fact acknowledged.
Whoa, what happened there? Why did it jump like that?
Versus Derek Martin. Today is Monday, May 20th, 2024 at 9:06.
Quoted plaintiff's own words where she has in fact acknowledged her drinking issues. The immediate response from plaintiff was to file an amended complaint for divorce wherein the only change from her initial complaint was paragraph 10 and the correlating request for relief wherein she now requests sole legal, sole physical for herself and reasonable parenting time for defendant, indicating that it is in the best interest of the minor children for the plaintiff to be awarded sole legal and sole physical custody of the minor children with defendant having reasonable parenting time. Said amended complaint was clearly filed in retaliation of defendant's present motion and for requests for plaintiff to receive help for her alcohol addiction, and wherein he requested temporary custody until there's a positive movement for the plaintiff receiving the help that she needs. Parenting time as in the children's best interest, with restrictions as necessary just to keep them safe. Court monitored alcohol assessment and treatment and a child support based upon the Michigan child support formula. Between her first complaint and her amended complaint, plaintiff offered no facts or change in circumstances in the intervening 50 days since the filing of her complaint for divorce, although defendant received defendant's response to her amended complaint on May 8th and has had defendant's motion since May 6th. She failed to file an answer timely, filed her hearsay evidence attached to her answer on Friday afternoon, not allowing us time to do any kind of a reply. We know that we were trying to work together and work something out, but still, that was still kind of attack by surprise when in fact that's not what had been claimed in the first time around. We believe that plaintiff's outlandish allegations, which appear to be from her anger with defendant for bringing up her alcohol addiction at all, the creation of documents to support her answer questions not only her veracity of the signer, but the ethics of all those acting in conjunction with the plaintiff. Step one of alcohol reliance is admitting there is a problem, and although plaintiff wrote it down, she will not admit in public she has any issues, which is sad, and she's not going to get the help she needs until she's admitted that. Defendant doesn't believe that plaintiff's a bad mom. He believes unless she gets an assessment and treatment for her use of alcohol, she will continue to put the kids at risk, as she has acknowledged in her own words, in her own writing, that she's done in the past. I believe it should be clear to the court that under these circumstances and with recent police involvement, these parties cannot peacefully reside together, and plaintiff has repeatedly stated her intent to move out. In fact, her plan was to move last Friday, but then she got mad at defendant and it had chosen not to leave. Then I thought she was partially moved, but I'm not. I know that was the agreement of the parties, and so we're asking that the court award defendant exclusive use of the marital home and require the plaintiff to move forthwith. Without random monitoring, defendant believes that plaintiff will continue to play the system as she has through testing her breast milk prior to nursing to make sure there's no alcohol in it, although she claims she knows after 3 hours there will not be, and so no one would have cause to contact CPS. Through hiding her issues and orchestrating her co-workers not to tell. Defendant is prepared to testify as to all the allegations are truthful, and the ones with quotation marks are absolutely actual written words by the plaintiff, meaning she knows she has a problem, simply will not admit she needs help in detriment to her own children. In attempting to work something out with plaintiff to get help, defendant had offered a forensic assessment and evaluation with Dr. Haugen with treatment as he sees fit, and was prepared to have Dr. Haugen even review the defendant's suggested use of SoberLink as the first step to a solution. Defendant was also willing to defer plaintiff paying him child support until the beginning of next year for the sole purpose of helping with the costs related to SoberLink. With random testing and whatever criteria this court may believe is in the best interest of the children regarding any missed tests and or positive results should define the parenting plan on a temporary basis. And of course, defendant defers to the court and your expertise with regard to that. Mr. Martin simply wants his children to be safe. And until there's help, until there's an assessment, until we're asking a forensic assessment because that's the only way that the entire story is going to get to Dr. Haugen. One quick mention that we will say, for example, with the attachments and all this, is that the photo that plaintiff decries is from the same day as the day she filed for divorce is incredulous to me, as she filed for divorce on March 18th, 2024. And that particular photo was posted on Facebook on February 4th, 2024. So more than a month beforehand. So unless there's magic clairvoyance or something, it's just a continuing ongoing lack of veracity. We're asking that this court keep these children safe, grant Mr. Martin the exclusive use of the home, him on a temporary basis have custody, and then have Dr. Haugen involved. We're more than happy to share with Dr. Haugen what we believe the SoberLink, the two-step plan should be. And if he thinks that's excessive, that's fine. But we want to make sure the kids are safe when they're in mom's care. We think she's a good mom when she's not drinking, but that's not what's been happening, and we have to make sure they're safe. So we're asking the court order accordingly.
Okay, Ms. Reed?
Your Honor, my client denies all allegations of alcohol abuse or substance abuse. She is currently seeing a counselor to deal with defendant's emotional, physical, and mental abuse that he has escalated since he's been served with the complaint for divorce. We did amend that complaint as he escalated his abuse since he was served to so legal and so physical, as it's abundantly clear that the parties can't co-parent and can't communicate well, as evidenced by the defendant's example in his motion of my client simply creating a bubble machine for Roman to play with. He manipulated it and turned it into some sort of incident of child abuse and neglect, that my client was putting this child at severe risk of harm. They were putting together a bubble machine to play with. This is ridiculous. My client would agree to doing a substance abuse evaluation with Dr. Haugen to disprove the defendant's outrageous claims that she's drunk all the time. Her employer has never reported she has a spectacular work history. Her coworkers will testify that they have never seen her drunk at work or drinking at work. The doctor for the children will testify that my client is providing and scheduling the child's care with the doctor's offices, provides soothing and comfort for the children when they're upset at the doctor's office, and she's a fantastic mom. We find it very interesting that he claims that my client's providing a unstable environment or a dangerous environment and is at risk of putting these children in danger when she's been the parent that provides care, comfort, clothing, feeding the children, doing everything for these children. She's the parent that gets up at night and soothes London and feeds London while the defendant is sleeping, and he sleeps through her cries.
I don't need anything more. What I'm going to do is, in this case, obviously, we are diametrically opposed to testimony, if you would, of offering that, or positions in this case. So the court's going to need at least some evidentiary hearing in this matter. What the court is going to do is, I'm going to schedule this for a limited scope evidentiary hearing on June 5th. It's a Wednesday, June 5th at 2:00 p.m. I'm going to allow each of the parties to have 1 hour to present their case through obviously their own testimony or others, but they'll have 1 hour each, and that's taking into consideration direct and cross-examination, and the court will reserve and make a decision at that time on the motion in this case. So we will see you all back on June 5th, and
holy shit,
it all
it's just
taken
like,
care of at
no.
that time.
Judge, can I ask a couple questions? So at that hearing, can we bring witnesses should we so desire?
You have 1 hour. So
Okay, so
if
use
you-
any way I want to.
If you bring witnesses and don't have your
Okay.
client, you're taking up your hour that way.
Nope, that's fine. Okay. And
So
then,
each party will have 1 hour, and that's including, I'll keep track of cross-examination and examination. So
okay,
obviously, use your hour the way you want.
nope, that's fine. And
Okay.
then it sounds like that, I guess a couple other things, and I didn't mention that Ms. Reed did not either. I believe
What happened? What happened there? Did you see this? It just
Use
cut.
your hour the way you want.
nope, that's fine. And
Okay.
then it sounds like that, I guess a couple other things, and I didn't mention that Ms. Reed did not either. I believe
I don't.
Right. Now we're moving on to our 9:30s.
Yeah, we could have kept Miss Reed in. I know.
Oh, I'm gonna check in.
Make sure we get that put on the schedule, the
Yes.
June 5th date.
And we do not have parties present. We have two 9:30s and I'm gonna stop the live stream. Please unmute.
What, bitch?
Okay, if you want to, you can just
Yep,
put me back in and then you can start checking in or do what you need to do.
all right.
Okay.
Good morning.
Good morning.
Your name, please?
Dejanette Craig.
All right, the naming on the screen here.
Little gremlins in the internet, they always cause problems. But my name is not Samsung, it's Dejanette Craig. Fuck, I would not have guessed that's what she said there.
All right.
You back?
Bring Judge in. All right, Judge. This is the Craig versus Edie case.
Okay.
Calling case 2021-1298 Dejanette Craig versus Ladero Edie. Today is Monday, May 20th, 2024 at 9:31 a.m.
Court will note the appearance of Ms. Reed on behalf of the defendant. This matter is before the court on the defendant's motion for parenting time and for modification of support. Ms. Reed.
Thank you, Your Honor. We're here to get my client a parenting time schedule because the order that was entered in 2021 just says parenting time as the parties agree. And the plaintiff has interpreted that as no parenting time, and he hasn't seen his children in quite a while. So we're wanting an enforceable, reasonable parenting time schedule and then child support modified accordingly.
Okay. Ms. Craig, what's your response?
He can take his child support, but I mean, my kids don't. We've been through. He's not seeing my kids.
He's what?
He's not seeing my kids, but he can get his support.
Okay, well, what he's claiming is he says, I want to see my kids, is what he's saying.
Okay, but my daughter just now became back being a kid. We went through something with him where my daughter was scared to use the bathroom. My daughter was scared to take baths. My daughter I do not allow him to see my kids. And I do it for the safety of my kids. I feel like I tried to reach out for help. I got no help. So I took it into my own hands. He can take his support, but no, sir, I'm not going to let him see my kids.
Well, ma'am, if I order him to see the kids, he will see the kids or you will go to jail. So we'll get that matter straight right now. Did you contact DHHS when you said you had some issues?
He contacted them as well. He's contacted them on me a lot.
Okay, so DHHS has been involved previously.
Mm-hmm.
Well, what the court will do is order that within 14 days of today's date, that the parties will exchange their paycheck stubs or the 2023 tax returns if they filed. And then Ms. Reed can take that and calculate the support based upon what that amount is. Ms. Reed, obviously she's brought up some issues, the kid's not wanting to go. Is there some utility to having a counselor involved to make a recommendation?
It might be helpful. I don't know how busy Margaret Hunter and Meredith Katz is right now, but regarding CPS, we requested the entire CPS file for this party, and the last issues were, I believe, in 2021, and I don't think anything was substantiated.
Okay, well, why don't we do that? We'll let you get that. Court will send the matter to either Meredith Katz or Margaret Hunter, whoever they can get the kids into first. and order that the parties would cooperate and have the appointment scheduled. Why don't we try Miss Katz first? I know Miss Hunter, I just had her on something. She was pretty busy, but let's do it with Miss Katz first. And if can't get into Miss Katz, then we'll do Miss Hunter. I'll order that the parties would communicate with Meredith Katz office within 30 days of today's date to set up an appointment for the children to, again, to talk with her. And then she can give us a recommendation as it relates to parenting time.
And is it going to be parenting time at the recommendation of Ms. Katz, or are we renewing a motion once we have the recommendation?
Once we have the recommendation, I just say the court will consider her recommendation, but I never defer to the counselors on those. So what we'll do is simply have her do a report in that, and then we will have a short hearing if we need to at that particular time. The court will order that, again, that the parties would pay 1/2 the cost of the counseling. Anything else, Ms. Reed?
No, Your Honor.
Ms. Craig, anything else?
No.
Okay, thank you. That will be the order of the court. You can submit that under 7-day.
Thank you.
Have a good day.
Interesting. I hope that you guys had a good night tonight. I apologize for the jumpy court. I don't know what that's all about, but I appreciate you. I say good day, sir. I am still thinking about food. I have my list tippity tap tap written up. And I am going to make the strawberries because they're on sale. I got a pound of strawberries for $2.44. That's a good deal. And I'm going to do the dipped strawberries in the sugar that's crunchy, like the Korean style strawberries or Japanese or whatever. You know what I'm talking about. They're all over the internet like 8 months ago. So that would make sense that I'm starting it now. I'll try and make a video of it. I'll try and use the camera. I hope everybody has a wonderful evening. Reminder that I love you. I am proud of you. And I will see you in the next video. You make the candy with sugar? Yeah. I have a simple recipe I'm going to try. It's just sugar, water, and strawberries. That's it. That's all.